Um, Hi, everyone. Thanks for joining. We will get started in just a couple of minutes after waiting for a few more people to join the webinar. Hey, everyone. I think we're going to give it just a couple more minutes for people to join, and then we will go ahead and get started. Thanks for being here with us today. Right. I think we can go ahead and get started, and then if more people join, um, we'll have an intro for a little while anyway. So hi, everyone. Thanks for joining us. My name is Shloka Krishnan. I'm the volunteer coordinator at the AIDS Legal Referral Panel. Excited to have you all here today for this training on bankruptcy presented by Marty Simon. I think a lot of people on the call are new to ALRP, so I'm going to do a little introduction, and then we'll move into Marty's training, and we will have time for a Q&A at the end. This is slightly important. Once you leave the webinar, you will be redirected to an evaluation form. Please make sure to complete that form because that's what will prompt me to send out a certificate of attendance for MCLE credit. You'll be directed there automatically when you leave the webinar, and you'll also receive the link in your email tomorrow. And then give it a day or so, and then I will send the receipt out. It's not like an automated thing, so do not be worried if you don't receive it immediately. Some quick housekeeping. The training is being recorded. Participants are muted, but if you have questions at any time, please feel free to enter them in the Q&A section, and we will either get to them during the training if that makes sense, or we will also have time for Q&A at the end. As I mentioned, please complete the evaluation form. And I sent out the presentation materials to everyone earlier this morning. If for some reason you didn't get them, reach out to me directly. I can definitely reshare. So just a quick introduction to ALRP. ALRP was founded in 1983, which means we are marking our 40th anniversary this year. Our annual reception is actually coming up next Thursday. So if you're interested in joining us there, please, go online, buy a ticket. We would love to see you there. Our mission is to help people living with HIV or AIDS maintain or improve their health by resolving their legal issues. When we were founded in the 80s, really what ALRP was doing was helping draft emergency wills for people who were dying very quickly. Thankfully, the landscape has changed since then, but there are still real challenges associated with managing a chronic health condition that can be, impacted by stress, impacted by housing instability, by immigration status. So what we're really working to do these days is address those needs so that people have the stability they need to be healthy and thrive. And we do that. So we do that in two ways. So first, we have about 15 in-house staff attorneys, primarily working in housing, although they do have some other areas of expertise as well. And then in addition to that, we have a panel of about 400 to 500 volunteer attorneys who we can refer clients to. And so that's really how a lot of our clients receive comprehensive legal services, because our panel attorneys' expertise really runs the gamut of civil legal services, from immigration to family law to bankruptcy to any number of things, which is great because they can provide our clients with the expertise they need in a moment of need or a moment of crisis. So since 1983, ALRP has handled over 80,000 legal matters for people living with HIV or AIDS in the San Francisco Bay Area. These days, about 80% of our clients are living on an income of $30,000 or less a year. So the free and low-cost legal services that we provide or connect them to can really have a really important impact in their lives. So just a quick pitch. Our goal in offering these trainings is really twofold. So first, we're just, looking to expand the capacity of attorneys in the Bay Area who are providing services to our clients, or in general. But also, we're hoping to recruit new talent to join our panel and provide services to ALRP's clients. So if you are not yet on the panel, I hope you will consider joining. I think many of our panel attorneys will attest that it's a meaningful and positive experience for them, and a meaningful way to give back to the community. It's also as small or large a commitment as you would like it to be. So in general, we ask that panel attorneys accept 2 referrals a year, but you always have the option to say no. You always have the option to say yes, and to be as involved as you would like. So what we do is we'll conduct a thorough intake with the client, identify their legal need, and sort of do some matchmaking to find an attorney who has relevant experience, maybe relevant language skills, and reach out to that attorney and ask them if they're with some, basic details about the case, and ask them if they're willing to consult with the client. And then only after you say yes, will we provide the client with your contact information, and y'all can take it from there. So nothing is ever sent your way without your approval. I guess, and so, all panel attorneys are also covered by our malpractice insurance, have access to our MCLE trainings, have access to mentoring from other panel attorneys. So I think it's hopefully a mutually beneficial arrangement for everyone. More information on our website. Also, feel free to contact me directly. Happy to talk more, answer questions, etc. That's the end of my little pitch. So we have today with us Marty Simon, who has been a panel attorney with ALRP for over 30 years now. She joined in 1993, which is incredible. In the past, Marty was also on our board and served as board co-chair. As a panel attorney, she has represented ALRP clients in bankruptcy proceedings and negotiating with creditors. In her law practice, she represents debtors and creditors throughout bankruptcy and insolvency matters. So excited to have Marty here today presenting for us. Thanks so much, and I will hand it over to you now.
Good afternoon. Thank you all for being here. And I reiterate what Sloka just said regarding joining the panel. If you're not already on the ALRP panel, I highly suggest that you do it. It not only is a great benefit to ALRP clients, but you will get great satisfaction out of it, I have no doubt. So I have been practicing bankruptcy law for many years. I represent both individuals and business debtors, as well as creditors when they are faced with bankruptcy situations. I represent secured and unsecured creditors and individuals and businesses on both ends. Obviously, we're not going to have time to review all the issues relating to bankruptcy, but I hope to go through various issues that will help you in your practice, whether or not you are a bankruptcy lawyer, a new bankruptcy lawyer, or you hope to get into the field, or you're representing a creditor that's affected by a bankruptcy. Bankruptcies have been relatively low in the past several years, attributed to the stay in collection activity. Loans stopped collecting, PPP loans were given, evictions were, moratoriums were in place. So all in all, there were very low numbers of bankruptcies recently. However, in the last year, that has changed considerably. There have been about 18% more individual filings over the past year, from August of last year to August of this year, and about 14% more commercial filings. So that is just, and it's anticipated that those filings are going to increase over the next few years. That is to say, it is a good time to get into bankruptcy law if you're looking for a new area or expansion of practice. And I will also mention that many of the old guard bankruptcy lawyers who've been around practicing for years have retired in the course of the pandemic, leaving a gap and a need for new bankruptcy lawyers. There are several types of bankruptcies. They're all set forth in the bankruptcy code. Here is a copy of the MIDI code and rules. If you intend to file any bankruptcy cases or be involved in bankruptcy, I seriously consider you get a copy of the code. That's 11 USC section 101 at SEC. Obviously, all of it is easily available online, but if you intend to go to court at some point, it's always good to have a handy edition of the code. If you're filing a case for an ALRP client, chances are you're filing a Chapter 7 or a Chapter 13 case. We're going to review those cases as well as other chapters. The first that we'd be dealing with is Chapter 7 case, and the Chapter 7 is what's considered a liquidation. A Chapter 7 can be filed by individuals or partnerships or a corporation. In the case of consumer debtors, they have to pass what's called a means test for eligibility to assure that they are eligible to file a Chapter 7 and that they are not in a position to enter into a plan to pay their creditors in part. We will get to that a little bit later more fully. There's no required amount of assets or liabilities in Chapter 7 case. And a debtor, a consumer debtor, is entitled to retain or exempt a fair amount of property, depending on a variety of issues, which we will also go into more in depth as we look at the voluntary petition. In a Chapter 7, a trustee is appointed. The trustee's job is to look at the assets and liabilities, the information that the debtor has provided, to verify whether or not there are any assets to distribute to creditors. If there are assets, those assets are distributed on a priority and pro rata basis to creditors. The vast majority of individual Chapter 7 cases are what are considered no asset cases. So there is no distribution made to creditors in those situations. In the case of a business debtor filing a Chapter 7, the trustee takes over the business, the doors close. If there's any, if there are assets to be liquidated, such as inventory or equipment, the trustee will liquidate that for the benefit of creditors. Most no asset Chapter 7 cases are closed, and an individual is discharged of any personal liability within about 4 months from the filing of the case. If there are assets, the case may stay open for longer than that. Although a individual gets a discharge, a business does not get a discharge, but as a practical matter, the doors are closed, there's nothing to pursue afterwards. The trustee in a Chapter 7 is appointed when a case was disfiled. In the Northern District of California, where we practice, there is a small panel of Chapter 7 trustees, and the trustee is appointed sequentially based on when a case is filed. Secured debt in a Chapter 7 is not discharged. Personal liability for that debt is discharged, but the creditor can still pursue whatever the property is that is secured, such as whether it's the home or the car, or there's a UCC filing. What is not, there are certain issues that are in certain debts that are not dischargeable in a Chapter 7. For instance, most taxes are not dischargeable, although taxes that are more than 3 years old and cases and the returns have been filed, and there's a variety of other restrictions, but some taxes might be dischargeable. Most student loans traditionally have not been dischargeable. However, there have been recent changes with regard to student loan law, and I have provided some materials which we are not going to go through today, but you can look at if you have a debtor with student loans. They're materials that were provided by Judge Blumensteel of the San Francisco Bankruptcy Court for the Bay Area Bankruptcy Forum recently. Chapter 7 is the next significant chapter we're going to review. Chapter 13. Chapter 13 can be also filed by individuals and sole proprietors with a regular source of income. Corporations are not eligible to file Chapter 13 case. A debtor in Chapter 13 must have debts of less than $2,750,000. That number was increased considerably in 2022 when Biden passed what was known as the Bankruptcy Threshold Adjustment and Technical Corrections Act, which significantly increased eligibility for Chapter 13 debtors. A big advantage of Chapter 13 is that the assets are not liquidated. A debtor can keep their assets and enter into a Chapter 13 plan, which is used to determine how they're going to pay off their creditors, in part based upon future income that they receive. The Chapter 13, for instance, can save a home from foreclosure. A secured debt can be modified. In some cases, a lien can be avoided. A secured debt might be extended. The terms can be significantly changed in the context of a Chapter 13 case. So the Chapter 13 debtor enters into a plan for 3 to 5 years, depending on its income. Payments are made to the trustee, and the trustee distributes funds on a pro rata basis to creditors. That plan must be confirmed, and creditors can object if they believe for some reason or another that the plan is not proposed in good faith. In the Northern District, there is a standard Chapter 13 plan, so that if you want to do a Chapter 13 case, you should certainly take a look at the court's website, which I believe you should look at anyway. It's an invaluable tool. And the Chapter 13 plan form is on that website. Different trustees have different procedures. For instance, there's one trustee in San Francisco for Chapter 13. There's another Chapter 13 trustee in Oakland. They have different procedures. Chapter 13 also is an advantage for a co-debtor. In other words, there is a debtor filing in bankruptcy and there's somebody else obligated on that same loan or on a credit card debt. There is a stay of any collection activity as to that co-debtor, even if that person has not filed a bankruptcy. And we will be going over the filing of the procedures for filing all of these cases shortly. The next chapter of bankruptcy is Chapter 9. This is something that my guess is most of you will not be filing, but it's for municipalities. In 2012, for instance, the city of Stockton filed a Chapter 9 case, and it successfully emerged from bankruptcy in 2015. Chapter 11 is the large reorganization cases that we all hear about and read about in the papers. Retail bankruptcies, for instance, which have increased considerably. You've heard about Bed Bath & Beyond, JCPenney, Tuesday Morning. There's been a slew of recent retail bankruptcies, and it's anticipated there will be quite a few more. So although traditionally Chapter 11 was just for corporations, it is now available also to individuals, especially in places like California, where they have significant, debtor might have large secured debt and property they want to protect. So Chapter 11 is now available for individuals, where in California, for instance, there's high secured debt due to large real estate values, and they may be over the limits of the 2.75 for a Chapter 13 case. So they're eligible to file a Chapter 11. A debtor in a Chapter 11 is generally a debtor in possession, known as a DIP. There is generally not a trustee appointed, unless a creditor, or perhaps in some cases the court sua sponte, might come in and say that a trustee should be appointed because of the estate is not being properly managed for one reason or another. But in most cases, it is a DIP, a debtor in possession, that manages the Chapter 11 estate. And in the case of a business debtor, the debtor stays in business and may do an orderly liquidation of the estate, or they may stay in business, reorganizing by downsizing, reducing expenses, expanding in a way that's supposed to increase their business, whatever. The debtor provides a disclosure statement that's issued to all creditors that explains what has gotten them into the mess that they're in, what their financial situation is, and a bankruptcy plan as to how they intend to emerge from bankruptcy and have a successful reorganization. That plan is voted on by creditors and must be approved by the court. Many Chapter 11s can go on for years while assets are being distributed to creditors. In a large number of cases, Chapter 11s end up converting to a Chapter 7 because, optimistic as the debtor might be that they can reorganize, it's generally a very tough task. So many Chapter 11 cases are converted to a Chapter 7, or they're dismissed or simply go by the wayside. A recent addition to Chapter 11 is what they call Subchapter 5. And a Subchapter 5 is an expedited and a simpler and less expensive procedure than the traditional Chapter 11. And it is available to debtors with total debts of less than $7.5 million. So, and to be eligible, the debtor has to have had has to be engaged in a business, and at least half of their income has to come from that business. So an individual who no longer qualifies for a Chapter 13 case, but has debts of less than $7.5 million would be eligible to file a Subchapter 5 of the Chapter 11 case. There is a trustee in a Chapter 5 case who is supposed to negotiate with creditors, help the debtor to reach a successful plan. Chapter 12 is for family farmers and fishermen, something that if you're in the Bay Area, you might see occasionally with regard to fishing. In the Central Valley, it's more common with regard to family farmers. Chapter 15 of the Bankruptcy Code refers to cross-border cases where debtors have assets in more than one country. This was instituted in 2005, along with Subchapter 5, as part of what's known as BAP-CPA, the Bankruptcy Abuse Prevention and Consumer Protection Act. So those are the different chapters of the bankruptcy case. Now, I want to just review a couple of principles and advantages of a bankruptcy filing. First of all, a bankruptcy filing gives a debtor a fresh start. The classic fresh start is in the Chapter 7 case where an individual is no longer personally obligated and debts are discharged and they can move on without the financial burden they had before. One of the most important concepts of bankruptcy is the automatic stay. And the automatic stay enjoins any activity, any action against the debtor or the debtor's property. The automatic stay goes into effect as soon as the case is filed. It does not stay actions by the debtor. It stays actions against the debtor or the debtor's property. So in other words, if there is litigation pending in which the debtor is plaintiff, the debtor can proceed with that litigation if they so choose. As to a creditor responding to that, I always suggest that they get relief from the stay, file a motion for relief from stay in the bankruptcy court in order to continue the litigation and to respond to the debtor, even though the debtor is the plaintiff in the case. One of the things that is very important for creditors to know is to not violate the stay, because there are sanctions and contempt available, possibilities if a creditor violates a stay. It's also important to know that the bankruptcy is for honest debtors. In other words, it's sort of common sense, but it comes up from time to time. A bankruptcy has to be filed in good faith. If there's some indication that there's not filed in good faith, the discharge would be blocked, or a case would be dismissed or converted. Certain things will block a discharge. For instance, fraud. If a creditor files an action and finds that there is fraud in connection with any of the debtor's activities, the discharge could also be blocked. It's also an advantage in bankruptcy that a bankruptcy judge oversees everything. The bankruptcy judge that's appointed as soon as the case is filed oversees everything. They hear the motions, they hear discovery issues, they hear confirmation hearings. So the case does not jump around from judge to judge. Each judge has its own rules, its own procedures. So it is important, as I said, to take a look at the bankruptcy court website for San Francisco, which will lay out those procedures of each individual judge. So as I mentioned, that if there is a question of relief from stay, also judges can hear every matter that they want to. Judges can hear everything, not only financial matters. They also hear family law matters. They can hear trust matters. They can basically hear any kind of issues that come up in any other court. If the creditors or the judge determine that the case might be heard better in another court, the bankruptcy court can give leave to have it heard in the state court or another federal court, as the case may be. Now, let's go over a little bit of the procedure when you get a new client and there's a potential bankruptcy in the works. First of all, it is absolutely essential to get all of the information possible right up front. That means, what are the assets and liabilities? Who's coming after them? Why do they need to file bankruptcy? What is their current financial situation? And what do they anticipate to be the financial situation in the future? Everything must be included in bankruptcy schedules, which we will go over in a moment. That means everything that the debtor owns, everything that the debtor owes. I always suggest that it's a good idea to prod the client as much as possible because they may have forgotten something consciously or unconsciously, whether it's property in another country, whether it's something that they owe to their brother-in-law. Always try to spark the memory as to what the situation is. Debts include not only if there's a credit card debt, there's a collection agency involved. If there might be several collection agencies, all of these will get listed in the schedules. Any judgments, any lawsuits, any pending disputes, any mediations, any student loans, secured or unsecured loans, domestic support obligations, taxes, and the years of those taxes. Everything must be listed. Also, transfers that have been made by the debtor within 90 days, a year, and in some cases up to 4 years. Consumer debtors prior to filing are required to take a pre-filing credit counseling course. This is also something that went into effect with BAP CPA in 2005. And that pre-credit counseling course, pre-filing credit counseling course, excuse me, and a pre-discharge course, which is taken after the case is filed, but before discharge is entered. Both of those are done online. They are generally easy for clients to do. They're available in various languages, but a consumer case cannot be filed unless, along with that filing, it shows that the case has been taken. That is supposed to show that, in fact, a bankruptcy is appropriate. Really, the questions that are given in that online course are quite similar to what you would be asking a client regarding their assets and liabilities. So if they have all that information available for you, they should have that information available for the course as well. So let's take a look. Sloka, if you can open up the bankruptcy petition, the voluntary petition. Okay. So this is a form of the voluntary petition. If you can see it, this is a several page form which gives the basic information about the debtor: name, address. You can keep going down there. I'm not going to go through each of this individually, okay? But it's a several page document, and it says whether or not they have filed bankruptcy before, whether it's a Chapter 7, what chapter it is, what the estimate is of their assets and liabilities. And that information actually is going to be generated from subsequent schedules. Let's hold off for a second here, Sloka. In some cases, the client comes to your office and is in a panic because a home is about to go into foreclosure, or they have to appear at a deposition, or something that they've known about for a very long time but did nothing about, and an emergency filing is necessary. In that case, it's only the voluntary petition that is filed with the court, and all of the rest of the documents need to be filed within 14 days of that filing. I don't suggest that as a way to do things on an emergency basis, but sometimes in bankruptcy law, it happens. Okay, so now you're looking at a summary of assets and liabilities. We can keep going on this to the next page because that also is generated from other documentation. And then we get to here, to the Schedule A and B, which is property. And the property list, please ignore where something is marked as no or no, anything that's marked on this property schedule. It was just obviously a sample. The property includes everything. That means personal property, as you'll see on number 3 there, cars, anything that's leased, any sailboats, household goods. The advantage of this, the way it's broken down, is it's clear enough that hopefully people don't forget things, but even though sometimes they do. For instance, you're looking at equipment for sports and hobbies. You know, if they have a camera equipment, a camera collection, you've got to know about it. If they have fancy sports equipment, you have to know about it. And the value of that equipment is important. And it's not the value as of the date of the purchase of the item. It's what the liquidation value would be. In other words, I think of it as a garage sale value, which is obviously far less than they paid for the item. Some clients will have a sentimental value. Well, of course, that's worth a lot of money. To the debtor's benefit, it's better if it's not worth a lot of money. But jewelry, for instance, you're looking at number 12 there. If it's costume jewelry, it's really not an issue. If it's expensive jewelry and they have an appraisal, it's important to know that. Okay, we can keep going on this schedule. The cash, bonds, stocks, all of this obviously must be listed. And let's keep going a little bit. And if there's security deposits, for instance, that's also listed. If somebody has prepaid a loan or a lease or the apartment lease, they moved into their apartment and paid 6 months, that has to be listed. Okay, so everything else is pretty clear cut. Okay. One thing that was just passed was tax refunds. If, for instance, if they just filed their returns for 2022 and expect a refund, that would have to be listed. And the timing of that would be important, as we'll talk about in a moment. Okay, let's keep going then. And so we can keep going to Schedule C. And Schedule C here is the property the debtor claims is exempt. This is extremely important because obviously if a debtor is filing and they want to keep as many of their assets as they can. So to determine the property that's exempt, we'd look at SLOCA. If we can go to slide 2. C is the exemption schedule. California bankruptcy exemptions allow debtors to keep certain property that would otherwise be sold to pay creditors. Debtors choose between two sets of exemptions under California Code of Civil Procedure 703 or 704. Okay, this is unique to California and it is extremely important. This schedule is from Best Case Bankruptcy Software. There are various kinds of bankruptcy software, but it's important to get them if you plan to file a bankruptcy case, because it's important to have updates on a regular basis with regard to exemptions, especially. Also, the bankruptcy software will do the calculations and determine what is actually exempt and what isn't. So the 703 schedule that you're looking at now would ordinarily be used for a debtor who does not have real property. Generally, they don't have a lot of assets to protect, but this schedule gives an idea of how much is available with regard to a 703 choice of exemptions. This schedule is generally used for someone, as I said, who probably doesn't have real property. So on top of all of this list that you see is what's called the wild card exemption or the grub stake exemption. And that wild card exemption gives the debtor currently $30,000, a little bit more than $30,000, $30,825 of hold it a second. Stop, SLOCA. We'll get to that in a minute. So wildcard exemption under 703 is currently $30,825. That means that the person who chooses a scheme under 703 of CCP gets all of those exemptions that were listed plus $30,825. So if they have excess cash in the bank, for instance, that can be exempted as well. You're now looking at 704, and 704 is for someone who has real property to protect. So under 704 in California, depending upon the county that someone lives in, for instance, in San Francisco, a debtor can exempt $678,391 in equity in a home. What that means is, and that's depending on the county of residence. So for example, if a debtor has a home with a value of $1.5 million and a loan of $1 million, the $500,000 in equity is exempt pursuant to CCP 704. And under that case, a Chapter 7 might be available for that client. And so aside from that homestead exemption, which is considerable now and has increased considerably recently. So aside from that homestead exemption, they also get all of these other exemptions that you're looking at on Schedule C for the 704. Okay. Some items are the same under 703 and 704. Pretty much all household goods and furnishings are exempt unless there's something particularly valuable. But a couch that somebody paid $3,000 for at a garage sale value is, worth a few $100s, not something that a trustee would be interested in liquidating. Okay, so Sloka, let's go back to the schedules, please. And we'll go back to schedules D, E, and F, which all deal with secured and unsecured debt. So Schedule D is checked here that there's no secured debt, but if there is, obviously you'd be checking Schedule yes, and there would be a variety of secured debts listed, which might be car loans, mortgages, UCCs, whatever. Let's go on to the E and F, which is the next schedule, and these are the unsecured claims. As I said before, everything must be included. Better to include than omit. That includes not only the credit card company, but the collection company, not only the brother-in-law that you owe money to, but the judgment creditor. Is the judgment creditor secured or unsecured? Has there been any kind of a UCC filed? But make sure to include anything, any conceivable creditor or interested party. An interested party might be somebody who's not actually a creditor, but who you want to advise of the bankruptcy case. For instance, if there was a foreclosure sale that was about to happen, the foreclosure company is not a creditor, but it's a good idea to list them so they get notice. If we keep going to Schedule G, Schedule G is executory contracts and unexpired leases. Certainly a business debtor probably will have a variety of executory contracts on expired leases. The consumer debtor may have less. If the consumer debtor has a month-to-month rent, for instance, and they don't want to notify their landlord of the bankruptcy filing, and that month-to-month obligation is current, in some cases you can list the month-to-month agreement and not give notice, not include the name of the landlord for notice purposes. Schedule H, if we keep going, is the co-debtor listing. And as I said before, for Chapter 13 cases, there's a co-debtor stay. That's not the case within, not the case in a Chapter 7 case. Also, you'll see within the last 8 years, have you lived in a community property state? So living in California, you would be saying yes. And even if the spouse is not filing a bankruptcy, they have to be listed. And their debts, their assets in some cases will be included separately. Okay, let's keep going.
Hey, Marty, I just wanted to point out that we have a question in the Q&A. Lisa says, question regarding homestead exemption 704.730. I thought that the maximum amount is 600,000. Is the actual median value in the county even if more than 600,000?
I'm sorry, is that in the chat box?
It's in the Q&A section.
It's in the Q. Okay, let me just see what that is. Homestead exemption. Yeah, that 600,000 has actually gone up, and it's based upon the county of residence. So that amount that I gave is the actual number right now for San Francisco.
And then I also just want to mention that we have about 15 minutes left until the hour. So, and then we can do Q&A
Okay,
after
well,
that. So just want to give you a note regarding timing.
I'm going to speed up a little bit then. Okay, thank you. Schedules I and J are extremely important. You must consider in the income, whether there's going to be a increase or decrease in income at some point. Are they going to lose their job? Are they going to have additional medical expenses? Are they taking on more work? Okay, I'm going to keep going. I'm going to go a little bit more quickly then. The statement of financial affairs. That's the expenses, which is part of the budget. Keep going. And after that, we have the statement of financial affairs that provides, one more page. Okay. A more detailed background of the debtor's financial history. Statement of financial, okay, we're gonna keep going, and I'm gonna speed up a little bit more. And we get to what's called the statement pursuant to 2016B. And that is an important thing to know about, because that sets forth the attorney. Next page, the compensation paid to the attorney. One more. Although there is no set fee for a Chapter 7 case, and your Chapter 7 will basically be dependent upon the complexity of the case. In a Chapter 13, there are fee guidelines, and you should check the website and the trustees' procedures with regard to those fees. Chapter 11 is obviously more complex, depending upon the judge as well. Some will allow you to take lots of money up front, or some in the trust account. In any event, there are regular requirements in a Chapter 11 for reporting on fees. Okay, let's go to the next statement, the next page, because the next page is important, and that is the statement of current monthly income. This is what I discussed earlier about the means testing. So, although you might think current monthly income is the same as on Schedule I, in fact, it's not, because the current monthly income is based on what the debtor has earned in the 6 months prior to the filing of the case. And that is the means test. And it's extremely important to figure out what has happened in the past 6 months, because if they got a bonus, for instance, 2 months ago, chances are you're going to want to wait to file, so that spike in income is not included in the CMI, as it's called. Okay. If the debtor does not pass this means test, then they're really in a Chapter 13 case. All right, let's go on. Okay, so this notice, which is included in the bankruptcy petition, should also be given to clients prior to the actual preparation of the entire petition, because they should be advised of filing fees and what they're looking at. And also this gives a little bit of information generally about Chapter 7s, Chapter 13s. Aside from the fees that are listed on this notice, Chapter 13 fees are paid. Also, a Chapter 13 gets a percentage of the plan payments. And in a Chapter 11 case, a United States trustee is paid on a quarterly basis. Okay, let's go on to, okay, so at the end is the creditor matrix. You can keep going, and the creditor matrix is generated from the schedules as to all of the creditors who are listed, and the court uses that to give notice of the bankruptcy. So Sloka, if you go to the notice of bankruptcy, once the case is filed, and you'll be filing that case electronically, the court issues the notice of bankruptcy. Now, in this particular case, you'll see at the top, it says debtors may receive court notices and orders by email, sign up. Good idea to do. And this says, for the debtor listed above, a case has been filed, order for relief has been entered, and it says, do not file claims, okay? Because it's believed that it's a no asset case, okay? No proof of claim deadline. All right, so there's really nothing to do because the trustee who is handling the case doesn't think there's any assets, and so there's no proof of claim to be filed. If you go to the next page, however, afterwards, it was determined that there might be assets in this case, in this Chapter 7 business case, and the notice was issued of a possible dividend, telling creditors to file claims. Okay, so the creditor client, now you're on the side of the creditor. Let's keep going, next page. So the creditor contacts you, they've been notified of bankruptcy, and what should they do? They're obviously panicked, and the first thing you want to tell them about, if they don't know already, is that there's an automatic stay and they cannot do anything. Okay, so let's go down. Okay, we can go to the next page. So the automatic stay is in effect. Hearing that, and that happens as soon as the case is filed, as I said. Hearing that a case is filed is enough to know. Okay, so what can a creditor do? First of all, that notice of bankruptcy said when the meeting of creditors is. The meeting of creditors generally takes place about a month after a case is filed. And in that event, all creditors can appear and they can ask questions for about 5 minutes each. And meetings of creditors in this district are all held by phone. So if a creditor wants to know about what's happening, they can attend the meeting of creditors or you can attend for them. Okay. A creditor could file a motion for relief from stay. They have an eviction. They want to proceed with the eviction. They want to proceed with a foreclosure. They want to collect something under a judgment that's secured. Basis for relief from stay in bankruptcy are basically two. There's cause for relief, and it's not necessary. The property is not necessary for an effective reorganization of the debtor's estate. In a Chapter 7, it's a non-issue because there is no reorganization. And if the creditor wants to just wait until the case is closed, which is generally about 4 months, then they can wait and not move for relief from stay. If they want to continue litigation in another court, they might want to move for relief from stay. Okay, so the next thing that the creditor wants to do is file a proof of claim if the notice says that there are going to be assets or there's going to be a distribution. Even if the debtor has correctly scheduled the debt for the correct amount, the creditor should still file a proof of claim. A proof of claim is accepted unless it's objected to by a trustee or by the debtor. And it's used as a basis for distribution if there is going to be distribution in the estate. It requires an attachment of whatever the support is, whether it's a credit card statement or a mortgage loan, whatever. Okay, so there's a bar date and you want to make sure to file before the bar date. Okay, so proof of claim has been filed. The case is going along. It might be a Chapter 7 or a Chapter 11. Your creditor client calls in a panic. Not only does this debtor owe me money, but the trustee wants money back from me. That's a preference. Generally, obviously, they're concerned. They don't like this. The trustee or the DIP, the debtor in possession, has an obligation to pursue preferences for the benefit of other creditors. So a transfer has to have been made within 90 days or a year if the transfer was made by the debtor to an insider, such as a family member or a corporate officer. It has to be on account of an antecedent debt. What's antecedent? Antecedent could be anything. It's old. If an invoice is generally paid It's been paid in 30 days for a year, and all of a sudden it's paid in 45 days. That's an antecedent debt and can be recouped for the benefit of the estate. So if a debtor transferred $5,000 to his brother 6 months ago, that's could be a preferential transfer if it was not made as a contemporaneous change for new value. Those are the two. There are two main defenses to a preference. Once is a contemporaneous exchange for new value. In other words, I pay you something and you give me new value. Or it's done in the ordinary course of business. So the debtor has been paying one of its vendors, and it continues to do it in the ordinary course of business. So those are the two main defenses to preference claims. I'm going to kind of speed through a little bit. Fees paid to attorneys pre-bankruptcy, by the way, are not preferential because you've given new value. So you can keep going. We can finish this. I've provided several attachments, which hopefully you'll have a chance to look at home. I've listed some useful resources. There are various blogs which are also useful for Sloka. You can get out of the proof of claim. That's okay. Also useful to see. The seminar materials, I do suggest you go over. And if you have any questions, I feel like I've sped through this quite a bit, given quite a bit of information, which hopefully will be useful. And if you have any questions, I am happy to try to address them.
I think we have about 15 minutes reserved for questions. If anyone has anything, you can either pop it in the Q&A, or if you raise your hand, I should be able to unmute you to talk if you would like. Either of those options should work. It looks like there are a couple of things in the Q&A. Do you see those, Marty?
Okay. What is the equity exemption for 704 is one of the questions. Well, the 704 exemption, if you're talking about a homestead exemption, that's what I was talking about, that's based upon the county. So in San Francisco, it's the 681,000. If you're talking about equity and something else, I'm not quite sure. Equity, if you tell me what, if that answers the question, that should do it. The other question is, can you amend a proof of claim after an objection is filed? Oh, that's a good question. You can certainly amend a proof of claim. If it's objected to, you should still be able to amend it. Hopefully by the time it's objected to, you would be able to work out whatever the issue is with the debtor if you or if an objection is filed, the other thing is it might be litigated. You might be going into court to determine what the actual amount is of the proof of claim. And the issue is it a case where there's going to be a substantial enough distribution that it's going to be worth litigating the issue? That's the first thing you want to do. So if you're in a large case and you have a significant proof of claim, yes. If it's a small case and you file a proof of claim and the distribution is going to be de minimis, as it often is in a Chapter 7 case, you probably don't want to bother. So next question says, knowing nothing about bankruptcy, can you go over what the court appearances are like? How long till they're scheduled? Are they on Zoom, etc.? Yes. Right now in the Northern District where I practice, there are courts in San Francisco, Oakland, San Jose. Santa Rosa was closed a few years ago. Salinas is just being closed. Everything in the bankruptcy courts now are still available by Zoom. Meetings of creditors are by phone. Some judges are not in the courtroom at all in the district. Most of them are in the courtroom, and hearings are also available by Zoom. Each one has its own procedures. They change regularly. So it's certainly a good idea to look. Frankly, I have been appearing by Zoom now since the beginning of the pandemic. I find it very helpful and good, and the judges are fine with it. So, if you have a trial, you might want to be in court. But for motion practice, and I do a lot of motion practice, Zoom works perfectly fine. I think there was also a question about the timing, but I've lost that question. Okay.
Sorry, I accidentally hit it. I think it said how long until court appearances are scheduled was part of the question.
Well, what was the question? The timing?
Yeah, it just said how long till court appearances are scheduled.
Okay, so generally, a motion for relief from stay, for instance, is scheduled in 20 days. And can be longer, but you can have those matters heard in 20 days. So that's quite fast. If there's an emergency, you can get into bankruptcy court usually very quickly. The judges are generally quite amenable in having expedited hearings if necessary. Do the creditors who had to return assets ever get creditors who had to return assets ever get I can't read exactly what it is. I'm not sure what that says. Do they get a decent percentage? That varies quite a bit. If if you're talking about a preference claim, and ordinarily these are negotiated, I deal with a lot of preference issues on both sides. Usually there's a demand, then it's negotiated, and if it can't be negotiated, it goes to court. Do they get a significant part? Something I've negotiated preference actions where they get nothing. It's totally dependent upon the trustee, upon what the assets are. Often a settlement agreement in a preference action will say, okay, I'm giving you back this amount of money, but I no longer have any claim in the the estate, or I'm not giving you any money, but I'm keeping my claim in the estate. Somebody asks about in a business owner, sole proprietor, list both social security and EIN. You would list whatever. Yes, I mean, if this is an individual case, and it's a business owner, sole proprietor, yes, you would list both. I see what you're asking. Yes. Somebody else has asked, in an emergency filing, is there an additional filing fee? If you file the original petition, and then you're going to file additional documents, usually there is an additional filing fee, as there is normally if you amend any of the schedules. So you could file all the schedules, then have to amend Schedule I for some reason. Ordinarily, there's an additional filing fee. That varies on what the filing is, and you have to check the court website for that. Also, if it's an emergency filing, you want to make sure that you notify whatever creditor it is of the stay, that assuming that there's a reason you're doing this emergency filing.
It looks like that's all the questions we have right now.
Okay.
Does anyone else have anything? Okay. I think that we can wrap things up then. As I mentioned, when you leave, you'll get a link to an evaluation form. Please submit that. You should have both my and Marty's contact information from when I sent out the materials. Oh, there is one question here. Beth says, cannabis businesses cannot file bankruptcy, is the question.
Okay, well, that's an interesting question. There have been many bankruptcies filed by cannabis businesses. You know, there's still the issue of the legality versus state law versus federal law. Essentially, a debtor cannot have its income from an illegal business, and that's been the basis for, you know, cannabis issues. If you have a client that's got a dispensary or in the cannabis business, I suggest you take a look at the case law. There's been a variety of recent case law, and also there have been quite a few seminars given on it. So you might want to check online for recent seminar materials about it. California and Colorado have both had quite a bit of case law, I think, on cannabis dispensaries. But the key issue is that a debtor cannot be its income cannot be supported by an illegal business in bankruptcy. I hope this has been helpful to you. If anyone has any questions, you can feel free to email me and I will try to respond, or give me a call. But I do suggest, again, get on the ALRP panel if you're not in it. Get into bankruptcy if you haven't been, because too many people have been retiring. And there is also, I should say, the San Francisco bankruptcy, the local Northern District bankruptcy bar is a really good, fun bar to be with. They're interesting people. And the bench is an excellent bench. The bankruptcy judges are really excellent judges as a whole. I won't pick and choose, but on the whole, it really is a very good bench, and it's a good practice to deal with. So thank you all for being here.
Great. Thank you so much, Marty.
Okay, thank you, Sloan.
Great. Have a good afternoon, everyone.
Bye-bye.